All right, good afternoon, everyone. We're going to go ahead and get started. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams. Excuse me. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused by the Solicitor General and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have the right to an attorney at this proceeding today. This proceeding is being conducted over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch. When I ask if you understand your rights, that is what I am referring to. Ms. Bridgewater, what is my reset date?
Yes, Your Honor. It is February the 6th.
Thank you. Those who receive a surety bond or a cash bond will be reset to state all purpose on February 6th, whereby aspects of your case, including bond, can be revisited. Those who receive a signature bond, whether through the jail or pretrial, will be reset further notice. I see that Ms. Kim still needs to interview one client. Are any other attorneys need to conduct interviews?
Yes, yes, Your Honor. This is Keith Cook. I have to interview 4 clients.
4.
Yeah, I don't know. Well, I interviewed. They put one on this morning, and then they went away, and they started calling me about 2 minutes ago, but we'll probably just need to weave it into this proceeding.
Okay, we'll do what we can.
Okay.
So there's 5 people that need to be interviewed, and the calendar only has 13.
I know. I don't know what I'm to jail today, but
Oh, and not even 13. Okay,
Okay.
what we'll do is we'll take as many as we can. And if could Mr. Cook start doing his interviews by phone now?
Well, I got one person already on the phone. You can just go ahead.
Oh, okay. Who is that?
Miss
Gutierrez?
Gutierrez. Yeah.
Okay. Let me see if I can find her.
Mr. Squatson. All right. Who do I have at courtroom 2? Can I do this case?
Yes, ma'am. Position number 2.
All right.
Yes.
Mr. Bryant, your case is 24 CR 0000476. I'm sorry, 00476J. You're charged with battery in this case. Do you understand your rights?
Judge talking, please, sir.
You understand your rights, Mr. Bryant?
Yes, ma'am.
Yes.
All right, thank you. Mr. Howard, can I have the history, please?
He had a 2020 wrongful use of marijuana out of the Army. He got a hold out of Newton County. Jail was the recommendation.
Good afternoon, Your Honor.
So what is the Newton County hold? Do we know what it is? No?
I don't know.
Okay, thank you. All right, Mr. Walker, please proceed.
Yes, right. Law enforcement was dispatched to 3055 Cadiz Circle, where they met with the victim. Her name is Jaleel Bryant. She advised that her and the defendant were in a verbal disagreement, at which time he did slap her cell phone out of her hand, causing the cell phone to hit her in her lip, causing a laceration. The state is asking for a signature bond through pretrial services, no contact with the victim, a stay away from the incident location, no weapons, drugs, or alcohol while out on bond, and I believe the victim, Ms. Bryant, is on the line.
All right, Ms. Bryant, if you'd like to make a statement, I need you to turn on your camera Unmute your screen and raise your right hand. What was the first name, Mr. Walker? Oh, okay. You need to unmute as well.
Okay.
All right. Ms. Bryant, do you swear and affirm the testimony you give today be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am, I do.
All right. Thank you. You can put your hand down. The defendant today is entitled to receive a bond as this is a misdemeanor offense. If you disagree with something that Mr. Walker said, that is what I'm not really concerned with that. I'm most concerned with any concerns you have for your own safety and whether you wish to have contact with the defendant. In light of those instructions, what would you like to tell me, Ms. Bryant?
I am in fear for my life from him. Him and his sister were threatening to push my wig back, meaning like shoot me in the head. So I don't think he should be allowed over here, any contact, anything.
Okay. Understood. Thank you. And I appreciate you coming to court and making that statement.
You're
Mr.
welcome.
Ty, anything further?
Yes, Your Honor. My client is a 29-year-old military veteran. He does have one child. He has strong ties to the community. His family and friends are here in Georgia. He works at the Atlanta airport. He was visiting his sister yesterday to celebrate his birthday, which was yesterday. He has no violent history, just that marijuana charge, I guess, when he was serving in the military. He does deny the allegations, and he states that his sister and nephews, ages 10 and 12, were in danger. And in fact, the complaining witness left a hole in the children's bedroom door. The warrant does state that the complaining witness hit the minor child accidentally with the door, but that was the children's bedroom door. She lives upstairs, from what I understand, and came down to, I guess, confront my client and his sister about the volume of the music with another person. She came down to confront them. Because of the circumstances here and the very limited criminal history, I'm asking for a signature bond through the jail. And he doesn't know about the hold. I'm going to call Newton County to see if there is a hold, but I guess the jail will deal with that.
Okay, thank you. Defendant will receive a $4,000 signature bond level 1 through pretrial. He's to take the 1-day anger awareness course. He's to have no contact whatsoever with the alleged victim and stay away from that incident location. Additionally, he's to have no drugs, no alcohol, and no weapons as a condition. Is there anything additional?
Your Honor, can I request a one-time law enforcement escort? He does have his phone and some other things there.
Yes, he can return one time with a member of law enforcement to get any items as necessary.
Thank you.
All
Can I
right.
also say something?
I've heard from you, Ms. Bryant. There's really
No,
nothing.
she was saying it. She has me confused with another person. She said the person I kicked the door, that was my
Okay,
sister.
I understand. If you have any disputes, you will have an additional time to speak about that. We're not adjudicating the facts of the case today, okay?
All right, and when will that time be?
If someone from the victim witness advocate may message you and get your information so that you can speak with them, okay?
All righty, thank you.
All right, take care. All right,
Sorry, Your Honor, and I would like to state, if that wasn't Jaleel Bryant, I mean, she shouldn't have been speaking at all.
My name is Kyra Julia Bryant, but that was me.
Okay. All right, I think we've heard. So let's move along. Thank you
Okay, Your
both.
Honor, I have a question. Is the charge battery or battery family violence?
I have battery. What's the correct charge, Mr. Walker?
Battery.
Okay. All right. Thank you.
All right, that concludes this case. Thank you all. Who do we have next? If we're able to move on.
Go ahead, XCDC. Go ahead.
I have position number 10.
All right, did they hear their rights at ACDC? I'm assuming yes. All right, good afternoon, Ms. Williams. Your case is 24 CR 0000474E. You're charged with 2 counts of theft by receiving. Do you
Well,
understand your rights?
This is position 10. Her last name is Turner.
Oh, that's position 9. The calendar is different.
It's
All right.
Williams and Patel.
This is Ms. Turner?
No, Williams. Williams.
Okay, so I don't know who was telling me something different. All right, Ms. Williams, do you understand your rights? I'm assuming that's a yes. Mr. Howard, can I have the the history for Miss Williams, please.
25 total. 2019 suspended license. 2019 probation. Her last stuff arrest was like '03, I think. This was level 1.
Okay.
Yes, Your Honor. The defendant was arrested for having 2 stolen bank cards belonging to 2 different victims. The first victim's name is Latasha McGrone. The second victim's name is LaShondra. I will spell her last name, Pauyo. The state is seeking a $1,500 surety bond on each count. No contact with the victims. No weapon, drugs, or alcohol while out on bond.
All right, Miss Kim.
Yes, Your Honor. My client is 39 years old, and she is a proud mother of 8 children and 3 grandchildren, Your Honor. She is the provider basically for the whole house with 8 children, Your Honor, and 3 of them, her own kids are adults, so only 8 minor children. She does not get any child support, so she's qualified for public defender services because of her indigency. And we would like to request for signature on bond through the pretrial level 1. She claims that she was helping some young kids and she didn't know anything about these incidents. She denies the allegation, and we would like to request for signature on bond through pretrial. Thank you.
All right, at this time, defendant will receive a $3,000 signature bond through pretrial level 1, 1,500 each count. She's to have no contact with either of the alleged victims and have no alcohol, no drugs, or weapons as a condition. Is there anything additional?
Nothing further from defense. Thank you.
All right, best of luck to you, Ms. Williams. That concludes your case.
Position number 3.
All right, good afternoon. Are you Mr. Bygrave? Mr. Bygrave, your case is 24 CR 000478C. You're charged with 2 counts of simple battery family violence. You understand your rights?
Understood. He got 2013 carrying concealed weapon out of Florida. It was dismissed. Level 1.
Okay.
That was a pocket knife.
All right, Mr. Pierre Thomas, please proceed.
Good afternoon, Your Honor. Brief facts of the case is on January 23rd, 2024. The officer responded to 57 St. Clair Lane, Northeast Atlanta, Georgia, and Fulton County, Georgia, on a domestic call. The officer spoke with the victim, who stated that the defendant sent her a text message regarding their 6-year-old son. The victim did not notice the text message. However, when the defendant arrived home, he arrived home aggressively and asked why she didn't respond to the text. He then assumed that she had blocked his phone number. The son became scared due to the argument. She tried to comfort him by hugging him. That's when the defendant picked up a cell phone and violently threw it at her. The phone struck her in the right side of her head, and it also struck the son in its hand. Given our office has not been able to get in contact with the adult victim, and so if we could sound for her, looks like her name is Lindsay, Linsay Belser, Belser, and the initials for the juvenile is A-N and then last name B. But given the limited criminal history, the nature of the case, Your Honor, the recommendation is a signature bond through the jail, no alcohol, drugs, or weapons, a stay away from the incident location, I would say no contact with both parties at this point. We don't have a representation from the adult in the matter, and the completion of a family violence intervention program.
Okay. Is Ms. Belser on the line and wishes to make a statement? If you are, please unmute your screen and raise your right hand.
Hi, I'm present.
All right. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I do.
All right, you can put your hand down. What I am most concerned with is any concerns you have about your safety, and if you have any fear of the defendant and whether you wish to have contact with the defendant. I'm not, this is just a bond hearing, and defendant is entitled to a bond today. If you wish to present other facts, there will be other opportunities at a later date. So really what I want to know about is contact. So what would you like to tell me in light of those instructions?
I would say that I am in fear of my safety. I would like to just request that we have no contact, as he stated, with the defendant. Also, that there be a third party present during the drop off of our child. In the past, we have gone through this where we decided to do 1 week on and 1 week off just to alternate being able to be present in our son's life. So I would like it if that could be possibly applicable to the situation. Also, we share a home, and as I've lived here over a year, I'm asking for the defendant to stay away from the residence until at least February 3rd, if possible, so I may have time to vacate the premises.
Okay. I appreciate you coming to court and making a statement. Mrs. Hay, please proceed.
Yes, Your Honor. My client is 38 years old. He does have the 6-year-old child with the complaining witness. He's lived in Georgia most of his adult life. He has strong ties to the community. He has a bachelor's degree in IT and works as a network security engineer. He does deny the allegations as stated in the warrant. And I'm sorry, I was on the phone with a last minute client, but I don't know if the criminal history was read, but I mean, he has one thing from, over 10 years ago, and that was a pocket knife. So I would say he has very little or no criminal history. He does own the home, but he understands that the complaining witness is in the process of moving out. I would like to request that he has to stay away until the date that the complaining witness stated, and then a one-time law enforcement escort at that time to confirm that she doesn't live there. And if so, then he can return to the property. And in the meantime, another one-time law enforcement escort just to get any belongings that he has in the home. No contact with Miss Belser is fine, but as she stated and his wishes, no violent contact with the child so that he can continue to be present in his 6-year-old son's life, and no objection to the signature on bond through the jail. We would object to the family violence intervention program. I would say a 1-day anger awareness at the most, nothing further.
And Your Honor, if I could just add, as our office has not been able to get in contact with the victim, she is in no rush or any obligation as the victim to leave the property. And so there's no temporal component that has to be put on that.
Okay. All right. Here's what we're gonna do. In light of the information before me, defendant is gonna receive a $6,000 signature bond through pretrial level 1, 3,000 on each count. He is to take the 1-day anger awareness course. He's to have no contact whatsoever with the alleged victim in this case. They can use a third party, however, to transfer the child. He can return one time with law enforcement to you know what we'll do? He can arrange with the third party to the first time to coordinate his items. And then he can use that one-time law enforcement, whatever day he so chooses. It can be after that date or earlier. I'm only going to give him the one-time escort with the law enforcement on one occasion. If the victim is no longer there, he can return to the location. However, if she is still there, he must stay away. All right. Is there anything additional?
Thank you, Your Honor.
All right. Best of luck to you, Mr. Bygrave. That concludes your case. All right. Is there another position we can take?
Position number 5.
All right. Are you Gabriela Gutierrez?
Ma'am.
And your case is 24 CR 0000481B. You're charged with battery family violence with the offense date of January the 23rd. Do you understand your rights?
Yes, I do.
All right. Mr. Howard, can I have the history, please?
It's a fifth arrest. She got 2 open cases in state court. Simple battery DV and battery. You want the case numbers?
No.
All right, that's it.
That's what they're open is good enough. Open battery? Okay.
And simple DV.
Okay.
Your Honor, respectfully, I think the battery should be a family violence battery, but it is not in the system. I will notate that. But respectfully, the Facts of this case is that on January 23rd, 2024, the officer was dispatched to 300 Stone Hogan Connector Southwest Apartment L7 in Atlanta, Georgia, and Fulton County, Georgia, on a person injured due to a fight call. The victim stated that she was inside of the home when she was approached by the defendant, who began to argue with her. The defendant then became physical and pulled her hair aggressively. The victim had to defend herself. Ultimately, the victim sustained a sprained and a broken right finger. Our office was not able to get in contact with the victim in this case. However, we are aware that there are the two open cases. In the open case 23CR004301B, it is the same victim as this current case. The original bond order was for no further contact and for her to complete an MHET that was given by Judge Morrow. It was a $3,000 good bond. It was later amended to a $3,000 signature bond through the jail to a no further violent contact. As we see in this situation, it is the contact has been violent. And I do believe it is a member of the same household on the simple battery family violence as the victim in this case, because the victim in this case is the sister, and I believe the victim in the other case is the mother. That's 23CR005963B. She was given a $2,000 good bond, and as with the other case, I guess they were handled at the same time on the same date. It was amended to a $2,000 signature bond through the jail by Judge Morrow. But the request from the state, Your Honor, is a $5,000 surety bond, no alcohol, drugs, or weapons, to stay away from the incident location, to have no contact with the victim in this case, and to complete a family violence intervention program. And as I stated, the victim in this case and that other open case is Amelia, Ameila, last name Carter, Carter. Nothing further to add from the state at this time.
All right. Is Ms. Carter on this line and wishes to make a statement? Okay. Hearing none. Is this your case, Mr. Cook?
Yes, Your
All right.
Honor.
Please proceed.
Sure. My client is 26 years old, has lived in the area her whole life. She has 3 minor children who are at this moment being taken care of by her grandmother at the I believe it's at the location. It was hard to discern that. We would ask for a SOB bond at whatever level the judge deems appropriate, given her financial situation, and an anger management as opposed to the family violence impact program.
All right. Defendant will receive a $2,500 surety bond. She's to have no contact with the alleged victim, stay away from that incident location, and have no alcohol, no drugs, or weapons as a condition. Is there anything additional?
I don't know if we need to double down on the MHET that was already ordered, or if we just need to leave it as is.
I'm gonna leave it as is at this time, but since it's going to state our purpose, if there's additional information, we can revisit the MHET then. All right, best of luck to you, ma'am. That concludes your case. Can we take Attorney Kurt's case next? Ms. Kurt, who is your client?
Milan Arrington, and thank you so much, Judge.
All right, can we take that position? Is that possible?
He's coming to the phone now. He was talking to the public defender.
Oh, well, Ms. Kurt's here for him.
Come on, Eric. He's position number 1.
All right. Good afternoon, Mr. Arrington. Your case is 24CR000477F. In this case, you're charged with reckless stunt driving, driving on the wrong side of the road, impeding traffic, and laying drag back in October. Do you understand your rights today?
Yes, Your Honor.
All right, Mr. Howard, do you have the driving history?
I didn't pull it, but it's his
Okay.
first arrest, level 1.
Okay, first arrest. All right, Ms.
Sure.
Kurt, please proceed.
I don't believe his history is, this is a first offense, and there's nothing significant on the driving history that I'm aware of. My client retained me Monday of this week, Judge. I reached out to the detectives on this matter. They wouldn't confirm that there was a warrant, that we became suspicious that there was one. and I had him voluntarily surrender last night. This is a first lifetime offense. I believe his father's trying to get on the Zoom call right now. He lives here in Atlanta with his mother, as he has for the last 7 years. He was working and employed until his vehicle was seized as a result of this incident, Judge. His family has retained counsel. They intend to help him resolve this matter. He's got no history of missing court. There, I believe, are only law enforcement witnesses, so he's not a danger to attempt to influence any witnesses. Obviously, there's no danger for him to commit other felonies, Judge. I think it's significant that he voluntarily surrendered as opposed to being waited to get picked up, Judge, as soon as he was aware of this warrant. And he is here with the support of several family members. I believe I've spoken to one cousin and 2 aunts, as well as his father, repeatedly over the last 48 hours, Judge, and they also intend to support him in a resolution for this matter.
And I think I skipped Mr. Thomas. My apologies.
The state does love Attorney Kirk, so I gave it deference.
I had to give my neighbor a little leeway today. I apologize. All right, Mr. Thomas.
Happy to see you, Mr. Thomas.
Always a pleasure. Brief facts of the case is that the officer became aware of a video that was uploaded to YouTube. The video showed multiple vehicles on a city street, specifically John Wesley Dobbs Avenue Northeast in Fulton County, Georgia. The vehicle was laying drags and stopped in the middle of the street. A 911 call actually came in on October 15th, 2023, that multiple street racers were under the bridge near the intersection of John Wesley Dobbs and Bell Street Northeast. That bridge is the overpass for 7585. The officer was able to identify one of the vehicles based on the license plate reader, a City of Atlanta's license plate reader, and it was in the city limits of Atlanta. The vehicle was a black 2011 Chrysler 300 four-door sedan with Georgia's plates that was registered to the defendant. The vehicle, along with others, did block the eastbound lane headed towards 4th Street Northeast. While the execution of a vehicle search warrant was being conducted, the defendant himself admitted that he knew that he knew why the search warrant was being executed, and that he did admit that he knew that the reason was for him doing burnouts, which is also known as laying drags. In the YouTube video, the defendant could be seen driving down the wrong side of the road, laying drags, because the rear tires of the vehicle were emitting smoke, and that he did not let other vehicles move, impeding the flow of traffic. Your Honor, this charge, I guess the position of the state is that this charge is not just a nuisance, but it's ultimately a danger to the public, which is one of the Ayala factors. And so the request from the state is a $5,000 surety bond, no alcohol, drugs, or weapons. Nothing further from the state at this time.
And no driving restrictions are being requested by the state at this time, Mr. Pierre Thomas?
I would say no driving while out on bond. Yeah.
Okay, I'm just curious. The first time I heard that, I'm sure Ms. Kurt is going to object. Go ahead, Ms. Kurt, if you'd like to respond to Mr. Pierre Thomas's recommendation.
Judge, I don't believe there's any history of this previously or subsequently. I have not had an opportunity to review all the discovery in this case, but I would say with a clean history, Judge, it could be an isolated incident. He does need to work to support himself. His family and himself have taken this incident extremely seriously. I think he understands the gravity of what the charges are, Judge, and I don't think other than one isolated incident, he's got any history of endangering anybody in any manner. He would, Judge, at a bare minimum, I'd like him to be able to drive for work and court so that he can take care of himself. He is 21 years old. He's quite young. But he is here in Atlanta living with his aunt.
Okay. All right. Defendant is going to receive a $2,000 surety bond. I'm not going to put any restrictions on his ability to drive at this time. Additionally, of course, he's to have no drugs, no alcohol or weapons as a condition. Is there anything additional?
All right. Thank you.
Each one? I mean, 500.
500 each. Yes, ma'am. Thank you, Ms. Holly. 500 each count.
Okay.
For total 2,000. Judge, thank you very much for your consideration, and thank you for getting me quickly.
All right. Take care, Ms. Kurt. Have a good afternoon. Bye-bye.
Great to see you all. And you as well, Mr. Thomas. Take care.
All right, Ms. Arrington, best of luck to you. Who do we have next?
Position 6.
All right. Is this Ms. Patel? Ms.
Yes.
Patel, your case is 24 CR 000 472G. In this case, you are charged with criminal trespass You understand your rights? She's saying yes. Mr. Howard?
First, resident of South Carolina.
Okay. Mr. Walker?
I'm sorry, what is this, Patel?
Yes.
Okay, in this case, law enforcement was dispatched to the Canadian consulate located at 1175 Peachtree Street due to the defendant coming to their location. I'm not sure if there's some underlying MH issues going on, but she was saying that she was being followed and she felt scared for her safety. They gave her what resources they had to provide to the defendant at the time, but she refused to leave. Law enforcement was called. I believe her husband even came to the scene and begged her to leave, yet she resisted all requests to leave that property. The state is asking for a signature bond through pretrial services. Stay away from the incident location. No weapons, drugs, or alcohol while out on bond.
All right, Mr. Cook, in light of the information before me, I'm inclined to give your client a signature bond through the jail with the requirement that she stay away. Is there any objection or anything additional you would like to add?
No objection, Your Honor. I think that works best under the situation.
All right, defendant is going to receive a $2,000 signature bond through the jail. She's to stay away from that location on Peachtree Street, have no alcohol, no drugs, and no weapons as the condition. Anything additional? All right,
Nothing
best of
further.
luck to you, Ms. Patel. That concludes your case.
Petition number 4, Clark.
All right, good afternoon, Mr. Clark. Your case is 24 CR 0000479B. In this case, you're charged with battery family violence. You understand your rights?
Yes, ma'am.
All right, thank you, Mr. Howard.
2022 arrest out of Denver, assault, disturbing the peace. This was level 2.
Okay, thank you. Mr. Pearson?
Brief facts of the case is that on November 24, 2023, the officer was conducting a mobile patrol when the officer observed a black female in the parking lot located at 3235 Peachtree Road Northeast with several bags and suitcases on the ground. The victim stated that the defendant and her got into an argument because he wanted her phone, but she refused, at which point he began to punch her with a closed fist in the face to the body and pull her hair. The victim stated that the defendant then pulled into the parking lot at that location, which is a Wells Fargo, where he took the victim's phone property out of his vehicle, unloading them to the parking lot and told her to exit the vehicle. On December 2nd, however, on 2023, officer then spoke with the victim who gave statements that was confirmed by the original report in the body-worn camera. But she said that the original physical assault took place at 3060 Peachtree Road, Atlanta, Georgia, Fulton County, Georgia, where the defendant works as a security officer. She also advised that that her and the defendant have been living together for were living together for approximately 4 years at that point. Our office has been able to get in contact with the victim. She advised that they're no longer in a relationship. They no longer live together, despite the fact that she's pregnant with the defendant's child. She confirmed the events in the warrant. She stated that this is not the first time the defendant has been violent towards her, and this is not the first time she has called the police. She stated that they have a case out of Colorado. I don't know if it's open or closed at this moment. She states that they have had contact since the incident. However, it has not been violent. And she states that she's okay with having no violent contact with the defendant. The recommendation from the state, Your Honor, given the limited criminal history and the statements that were made by the victim and the totality of the circumstances, is a signature bond to the pretrial services, no alcohol, drugs, or weapons. I guess that's the incident location is his place of employment, so we would not be imposing us or asking for a stay away, for him to have no further violent contact with the victim in that case, and to complete a family violence intervention program. And the victim is listed as Essence, ASSENCE, Spearman, SPEARMAN. If you could sound from Ms. Spearman in accordance with Marcy's law, that'd be greatly appreciated. Nothing further to add from the state.
All right, Ms. Spearman, I see you on the screen. If you would like to make a statement, please turn on your camera, raise your right hand. You are not required to, but I will sound for you one last time. All right, Mr. Cook.
Yes, Your Honor. I wanted to verify, it's the stairway address, the Brett Street address?
There's no stay away being requested at this time. It's allegedly his place of employment.
Okay, thank you. Your Honor, my client is 27 years old. He is employed. He has one minor child. He would have no problem staying away from the location or any contact restrictions. They piled up my interviews in about 10 minutes. It
I
started at
understand.
1:50. One of those days.
It
And
is one of those days.
and it's not over. So
All right. So, Miss Spearman, I'm going to ask one more time if she's here. I know the state has said no further violent, and the state did have extensive opportunity to speak with her, Mr. Pierre Thomas.
We did, but we're okay if the court wants to impose no violent contact. I mean, no further contact if she doesn't want to give testimony in support.
Right. Okay. Because I have not heard from her, and Mr. Cook has represented it, his client is can live in a no contact situation. Defendant is going to receive $4,000 signature bond through pretrial level 2. He is to take the 1-day anger awareness course and have no contact with the alleged victim. Well, actually, Ms. Spearman, are you still here? I'll accept the state's recommendation and do the no further violent contact. Additionally, he's to have no drugs, no alcohol, or weapons as a condition. Is there anything additional?
Yeah, I just want to reiterate she's pregnant with his child, and so that was the indicia. But
Right, I understand that. I remember that. That's why I changed it, but I was trying to give her one more chance. No further violent contact. All right. Best of luck to you, Mr. Clark. That concludes your case.
You said 4,000?
Yes. Position number 8. All right. Good afternoon, Mr. Spotsville. Your case is 24 CR 000-473G. In this case, you're charged with battery family violence. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, can I have that history as well?
Ninth arrest, 2023 of obstruction, disorderly conduct, dismissed. 2021 trespass, no-low, 18 assault conviction, 13 robbery, evading detention conviction. Level 2. That's it.
All right, Mr. Walker.
Yes, Sharon. In this case, law enforcement was dispatched to the incident location. When they spoke to the victim, Miss Alexis Withers, she advised that her and the defendant were engaged in a verbal disagreement. When things became physical, he struck her in the face repeatedly. The officer did observe the victim bleeding from her nose, mouth, and swelling around her face. The state is asking for a no contact, a stay away from the incident location, no weapons, drugs, or alcohol while out on bond, and I can provide that location to the court momentarily.
Okay, and I'm sorry, the name of the victim again.
Alexis Withers. We have had contact with Miss Withers, and she is requesting a no contact and a stay away from her home.
Okay, is Ms. Withers present and wishes to make a statement? All right, Ms. Kim.
Yes, my client is 32 years old, and Your Honor, he has no objection to stay away and no further contact. Even though they are married, he is okay. He's gonna go to stay with his mother's place. Anyway, Your Honor, we do understand that okay, Alexis, there's one child they share together, even though he has 3 children total, 2, 7, and 13 years old. 2 years old is the one that he shares with, and he wants to have a third-party transfer to have a visitation with his child. He is currently working at McDonald's as a general manager. He used to work for the Vault as a chef, and he will not be qualified for public defender services. He successfully graduated from high school. We would like to request for signature on bond through pretrial level 1. Thanks.
All right.
Your Honor, before you make your ruling, we did talk to the victim. She said that they are not married and they share no children together, so there's no need for any contact.
Yep, that's okay, totally.
So we don't need a third. There's no child.
There's one child that he
No, it's not his. They don't share any children together. We talked to her. She said they share 0 children together.
Okay.
That's quite a different account.
Yeah, because my client believes that 2 years old son,
Oh, that's not
2 years
good.
old child is his child.
Is he legitimized by him?
Well, you know, Mr. Walker,
Well, I'm just saying if he's not legit, but we did talk to the victim and she said that they
that's
should
not
be
okay.
considered together. So unless
Okay,
he's legitimized, he has no rights. And she says it's not his.
Lord Jesus. Okay, defendant is going to receive $1,000 surety bond. He's to have no contact with the alleged victim and stay with it from that location. Additionally, he's to have no drugs, no alcohol, and no weapons. I am not going to do the third party transfer based upon that information presented to me. However, that can be revisited should he obtain any information regarding the paternity of that child. All right. Best of luck to you, sir. That concludes your case.
Your
Who do we?
Honor, I
Yes.
apologize, and yet I just want to verify that stay away was not ordered, right?
I don't believe the state requested. Oh, you
The
did
state
request.
did request to stay away. It's 532 Cleveland Avenue.
Yes.
Okay, that's okay. Because that's not my client's address, so that is okay.
Okay.
Thank you.
And so he'll stay away from that address on Cleveland Avenue.
Yes. Thank you, Your Honor.
All right. Best of luck to you, Mr. Sponsor. Who do we have next? I have that we're holding on 7 and 9.
Position number 7 is a medical reset. He's at Grady. Position number 9 is a medical reset.
So you got it on the books, right?
Okay. Ms. Kim, you were told, did you waive position 9's appearance?
I was not able to waive anybody because I wasn't able to speak to anybody.
To speak to him. Okay, they're both at Grady. Does that conclude the entire calendar? I believe so. Miss Holly Bridgewater, Miss Bridgewater, will you please review that for me?
I certainly will, Your Honor. Okay, once again, the reset date for the SAP calendar is going to be February the 6th. Position number 1 is being reset to that SAP calendar with a total $2,000 good bond. Position 2 is reset further notice with a $4,000 SOB through pretrial. 3 is reset further notice with a total $6,000 SOB through pretrial. 4, reset further notice with a $4,000 SOB through pretrial. 5 is going to the SAP calendar with a $2,500 good bond. 6, reset further notice with a $2,000 SOB through the jail. Position 7 is medically reset till tomorrow. Position 8 is going to the SAP calendar with a $1,000 good bond. 9 is medically reset till tomorrow, and 10 is reset further notice with a total $3,000 SOB through pretrial. Are there any questions,
Number
comments, or
6.
otherwise?
Give me the bond. I know it's jail. What's the bond amount for 6?
Number 6 is $2,000 SOB through the jail.
My sincere apologies. Tequila Brinson was on the pull sheet and it was submitted with everybody else and it doesn't have a CR number. And I don't want her to remain in custody.
Does anybody at the jail know where that defendant is?
I have no idea. Perhaps maybe someone else.
Is anyone, it's still at courtroom 2?
I don't remember the name exactly, but was she charged with the giving false information? I think they told me from the jail that she bonded out.
Okay. It still has the J on it, but okay. I was like, but
That's what they told me. I'm not sure.
Okay. Can the jail confirm before we go? No one's at the jail? Anybody have a number to call courtroom 2 very quickly?
I'll try.
Because if she didn't.
And the recommendation, just for the record, is a signature bond through the jail and just no alcohol, drugs, or weapons.
Okay, well, she might already be out, and I guess.
Give me 2 seconds, Your Honor. I can confirm whether she's in jail or not. Just 2 seconds.
Thank you.
She posted bond.
Yep, free LS bonding company.
All right, wonderful. Thank you all. I believe that concludes the calendar. Take care. We'll be in recess until tomorrow's SCA calendar. Have a good afternoon.
Take care, everyone.
Thank
Bye-bye.
you.